There are laws that often feel different from traditional surveillance statutes, and those are covered in this domain. Hello everyone, and welcome back to Privacy Professional Training. My name is Fumi Owolabi and I'm the founder of Privacy Professional Training. In today's video, we're going to be continuing our CIPPUS preparation by walking through some additional laws in Domain 3, Government and Court Access to Private Sector Information. So if you're looking for insights from Domain 1 and 2, take a look at other videos in the description. For today's video, we're going to be focusing on Domain 3 with a particular focus on national security and privacy. So the first law we're going to talk about is the Foreign Intelligence Surveillance Act, and we're going to be shifting into how national security plays a part in personal data processing and ordinary investigations. The Foreign Intelligence Surveillance Act, or FISA, applies when the goal is foreign intelligence. This law governs surveillance and information access related to national security threats. It includes specialized procedures and oversight structures. Now, FISA exists because intelligence gathering raises unique privacy questions. When you are continuing with your studies related to this particular law, you might start to think of scenarios involving intelligence agencies rather than the police. And some of the facts that you might start to think about in relation to your studies for the law might mention foreign threats or national security concerns. It may also be reference to surveillance rather than prosecution. Sometimes the setting feels broader than one single investigation, so that's definitely a consideration as you study and understand this law. When intelligence gathering is the central purpose, FISA often becomes relevant. This law helps explain how information can be accessed in that context, and recognizing the national security focus is key here. We've already looked at a number of other different privacy legislations from a government respect, but the recognition of being able to separate this law and its aim with respect to other privacy laws associated with government access is going to be key. A specific focus on Section 702 of the FISA really comes up often in discussions of modern communications. This particular section focuses on surveillance targeting non-US persons located outside of the United States. And this is the CIPPUS exam, so this is very unique to this test outside of other privacy search. This provision is frequently connected to emails and digital communications. Understanding who is being targeted and where they are located is especially important here. These details shape how this authority operates. Now, FISA is a very long act in and of itself, but this is specific to Section 702. In reviewing this law and understanding the material, you might encounter situations involving communications of individuals outside of the United States. The facts make it clear that the individuals are not US persons or US citizens. Scenario may involve data held by service providers. There's going to be lots of different service providers, and recognizing who is a service provider is going to be valuable in your studies. There may also be references to intelligence collection rather than law enforcement. Location and status matter a great deal when reviewing this section, and when those elements are emphasized, Section 702 may often come into play. This helps students explain why certain access rules apply during their studies, and paying close attention to those signals makes the scenarios clearer when reviewing Section 702. The next law we're going to be reviewing as part of the studies is the USA PATRIOT Act and the US Freedom Act. Both of these laws are best understood as part of an ongoing conversation. The USA PATRIOT Act expanded national security authorities after September 11, 2001. Over time, concerns about privacy and oversight have led to these changes. The USA Freedom Act adjusted some of these powers. In unison, they show how national security law evolves. I've talked a lot on this channel about how privacy continues to evolve based on what's happening within the world and its sphere, and I think this is a great example of how a particular incident has influenced how the processing of personal data can occur. Though some of the facts that might be included might be terrorism-related concerns, or alternatively a scenario that focuses on reforms or added limits. The time period or context often provides additional clues. These laws tend to appear when questions involve change over time. They help explain why authority may look broader or narrower depending on the context and the year, and seeing them together helps keep the timeline straight. I think this goes back into making sure that when you're drafting notes related to your studies, depending on how you study, making these key distinctions in what the laws cover is going to be key in helping you understand scenarios for questions. National security also includes cybersecurity cybersecurity. There are laws that focus on sharing information about cyber threats, and the goal here is improving security and preventing harm. Privacy concerns are still present, but the emphasis is protective rather than investigative at times. There are laws that often feel different from traditional surveillance statutes, and those are covered in this domain. You may encounter scenarios involving cyber incidents or network threats. Now, here we're getting into cyber security, and although distinct from privacy, I've talked in other videos about the relationship between security and privacy. They work hand in hand. Security looks at the protection of assets. Privacy looks at the protection of personal data. In order to host personal data, you've got to store it within assets like a computer. So you're going to encounter scenarios looking at cooperation and prevention, and there are privacy laws that hinge upon how cybersecurity is rolled out and adhered to in a privacy context. It's also helpful to explain how information flows between parties. You've got one repository to another repository, and the purpose of protection is really important from a cybersecurity standpoint too. You're going to see an influence of cybersecurity in this section as well, because it hinges upon how data can flow from one entity to another. The next law we're going to look at is the Privacy Protection Act of 1980. Now we're going to turn to civil litigation and the press. The Privacy Protection Act addresses situations involving media materials. It limits certain searches and seizures related to journalism. The law reflects sensitivity around news gathering and press freedom. It becomes relevant when government action intersects with media activity. So in terms of scenarios and questions you can be asking yourself while you're studying, you might see situations involving journalists or news organizations, and there may be facts that describe attempts to obtain notes or materials. In addition to this, there may be scenarios that involve government investigators. Press activity will usually be a key detail. Now, back to the law. It exists to address the exact intersection between the media and the government, and recognizing the role of the media is very essential in your studies. When journalism is involved, privacy concerns often shift. This law helps explain that shift. The next discussion in relation to Domain 3 is electronic discovery in civil litigation. Civil lawsuits often involve digital information. Electronic discovery refers to the exchange of electronic records during litigation. This process can include emails and documents containing personal data. Privacy concerns arise because large volumes of information may be shared. Courts play an active role in managing this process. And from a student perspective, you might encounter different themes as you study related to civil disputes involving electronic records. There may also be facts describing requests for emails or files. In addition to this, scenarios may raise concerns about scope or sensitivity. Now, this is not law enforcement or national security. It's about resolving disputes between parties, and those parties are private parties. And the emphasis on the court's oversight on how information is exchanged between these private parties. Now, privacy still matters here, which is why this is a part of the exam, but the setting is different, and recognizing the civil context helps frame any issues that might arise as you study for your test. As you can see, Domain 3 brings together several different legal frameworks, each designed for a specific purpose. The key is staying grounded in the context that's applicable for your studies and asking simple questions about who is involved and why information is being accessed. If you approach this domain one law at a time, it becomes more approachable. In the next video, we are going to move into Domain 4, which is related to workplace privacy, and explore how privacy issues arise in employment settings. I really hope you enjoyed this video. If you like this type of content, subscribe, and I will see you in another video.